All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning.
Good morning.
We are here for oral argument in Centerpoint Mechanic Lien Claims v. Commonwealth, which is our case number CV21 0039. So each side has 25 minutes for argument, which is a little different than normal. And then we had issued an order explaining the order. So if you can keep track of your own time, there's a clock up typically there. I assume you can see it to keep track of it. And you'll need to not reserve time for a rebuttal, but make time for a rebuttal. Meaning just watch your time, and the longer you have, you'll be able to. One side will be able to have a rebuttal they wouldn't have had, and the other side will have a longer rebuttal. So our proceedings are being recorded, audio and video. So please introduce yourself and your client when you start. This is important. We've read the briefs. We've discussed the case at length, and I would urge you to keep that in mind in making your arguments. So with that, counsel, you may proceed.
Thank you, Your Honor. Good morning. My name is Richard Lorenzen, and I'm here with my partner, Derek Peterson. We have client representatives also present, and we're very pleased to have this opportunity to appear here and attempt to rectify some serious legal errors by the trial court below. The first of those legal errors occurred almost 7 years ago when the trial court granted summary judgment to Commonwealth instead of CMLC. I should have identified that as my client, CMLC, on coverage issues. That ruling was erroneous on three independent grounds. The first such ground was that there had been a previous trial on reasonableness of the settlement that resulted in a Morris judgment finding that Commonwealth was bound by the fact and amount of the settlement, $5 million under each title policy.
But counsel, isn't it true that that issue had not been finally decided, although admittedly litigated? Isn't the fact of coverage, or the question of coverage itself, wasn't that known to have been reserved for a later time?
Absolutely. But the distinction is between issues relating to loss or liability on the one hand, which are subsumed within the Morris hearing, and issues regarding coverage on the other hand, which are available in the subsequent declaratory action. That's made clear by Morris itself, which says that the insurer cannot relitigate all aspects of liability because it would then have a prohibited second bite at avoiding liability. And in Wood, the Court of Appeals made clear that there is such a distinction and that essentially Morris prohibits the relitigation of liability issues or issues related to damages. What is permitted with regard to coverage, Your Honor, under Wood, Quihis, Martin, Monterey Holmes, Osborne 3, and Morris itself is for the insurance company to contend that the claims in question here, the mechanics liens, were not covered under the policy. And second, if they were covered, which they are, that they're subject to an exclusion from coverage under the list of exclusions. Martin makes that clear. Quihis makes that clear. Wood makes that clear. It's all of those cases dealt with a specific policy exclusion. And here, Commonwealth raised no coverage defense. Mechanics liens are covered. They're not subject. They don't contend they're subject to any exclusion.
But counsel, I'm sorry to interrupt, but doesn't the very nature of a lender's title insurance policy make that question somewhat more difficult to parse under I believe it's pronounced Kiwi.
Is it?
Yeah, but under the Kiwi case, which says that even if you have overlapping issues, you can continue to address those if they have not been decided. And Wood, I think, is distinguishable because in Wood, they actually addressed coverage issues first before they decided any issues regarding reasonableness. So let's set that aside. But why does, because the nature of title insurance has to do with repayment of loans, why does that not, why can they not litigate that issue if it hasn't been previously decided?
Well, that's a different question, and I would also suggest looking at the Martin opinion, because in that case, the insurer made quite clear, and the court made quite clear, the insurer is not contesting liability. Rather, it is arguing that a specific policy exclusion applies. That was critical to the holding. And in this case, title insurance looks to protecting the value of the insured property interest. And in this case, these arguments that the settlement should not have been approved because Universal had not suffered a loss, and because VRCP had not suffered a loss, were made in the reasonableness trial. Those issues were raised and litigated, and Judge Burke overruled those. He rejected those arguments, and he said, no, Commonwealth is bound by the fact and the amount of the settlement. Not just the fact, but the amount of the settlement.
But as I read Judge Burke's ruling on that issue, he doesn't really differentiate. He just says, I find that the Morse agreement is reasonable. He doesn't say, I find it's reasonable because the fact of damage and the amount of damage are reasonable. He says that I find that it's reasonable. So he doesn't, I'm finding a disconnect between what is sufficient and what is necessary. Your argument is correct if the decision about the amount of damage and the fact of damage being absolutely necessary to the settlement is true, but Judge Burke didn't specifically make that argument, did he? Or make that finding.
He made the finding in the judgment that Commonwealth is bound by the fact and the amount
but you're
of
saying
the settlement.
That implicitly.
Absolutely. They're bound by the amount. And the purpose of the reasonableness hearing is to establish a degree of damages and liability. That's what Morris and Wood, I believe, Kiwi, and Martin say.
But did you say, though, I thought I heard you earlier agree that coverage can still be litigated. Did you make that point?
I did, and by that, my understanding from the cases is that includes whether the claim was covered, and if so, whether it was nonetheless subject to an exclusion.
And how is that different from liability?
Because you look to the insurance policy first under the insuring clauses to see whether mechanics liens are covered. Here they are.
Right. But what I'm saying is, if you can challenge coverage, how is that qualitatively different than challenging liability?
Well, I don't know qualitatively, but they are two different concepts. Here, Commonwealth was relying entirely on provisions of the insurance contract called conditions, not on the exclusions, not on the covering provisions. And those conditions relate only to limitations on Commonwealth's liability for claims that are covered. They don't come into play unless there are covered claims. And in Monterey Homes and in Osborne 3, this court has said and held that the insurance company can't resort to those kinds of provisions in order to avoid liability under the Morris judgment, because to do so would give the insurance company a prohibited second bite at avoiding liability for covered claims, and because to do so would hamstring the insured's right to settle. So
Let me ask you, so counsel, you're here today, you could be wearing a hat that says Universal and whatever the acronym is.
VRCP.
Right. That's correct, right?
Yes.
Okay. What are your damages? And if we can just sort of bullet point, we have a loan, the loan is repaid. And so at that point, what are your damages, Universal and VCRP?
Well, first of all, VRCP's loan was never repaid. That's a fiction. Universal's loan was ultimately repaid years after the Centerpoint property was sold, and it was not repaid from the insured property, which was Centerpoint. And
what are your damages? I mean, let's just bullet point.
The damages under Swanson and Johnson Bank are the difference between the fair market value of the deeds of trust without the defect of the mechanics liens and the fair market value of the insured deeds of trust with the mechanics liens in place, which is about $19.5 million. And the issue is, leaving aside the Morris line of cases and another issue that I'll touch on in a minute, then the question is, at what point in time are those diminution in value damages to be calculated?
Counsel, before you get into that matter, isn't Swanson and Johnson, Swanson definitely, distinguishable because those had to do with owners' policies? We have a lender's policy here, right?
Right.
And that situation is qualitatively different from an owner's situation where an owner is going to be left actually with the property. A lender just has a security interest in the property. So when you're talking about diminution of impact or lasting impact to the property itself or the quality of the title itself, doesn't that form a distinction?
No, and that's what Commonwealth's argument is. But
why?
Because Swanson says an insured's damages resulting from a defect are what I described. In Johnson Bank, the court specifically says that the lender's policy, the court specifically says that the lender's diminution in value damages are to be calculated as of the issuance of the policies. It says that the lender has diminution in value damages. Equity income partners is a diminution in value case. The Arizona courts have adopted Citicorp. That's a diminution in value case. Commonwealth's own claims handbook acknowledges that diminution in value, where the mortgage is insufficient, the value of the property is insufficient to support the mortgage. That's what their claims handbook says. And then finally, their out-of-state cases, I don't know to what extent you're going to consider or review those, but they also say that diminution in value is the proper measure of damages under a lender's policy. But Blackhawk decision from the Wisconsin Supreme Court says most of the cases throughout the country that have considered the issue have found that to be the case.
Counsel, I have Johnson's Bank here. Can you give me a paragraph number that I'm supposed to be reading here?
Sure. It's one.
Paragraph 1.
The lender's diminution in value loss should be calculated as of the date the title policy was issued, rather than as of the date of foreclosure.
So maybe we can get to this from the opposite direction, which is there such a thing as mortgage insurance?
Well, I don't know, I'm not sure if you're distinguishing between a deed of trust or a mortgage, but
What I'm talking about insurance, that you'll be repaid the loan.
No.
Or that is the very object of the insurance. That doesn't exist?
I don't know, that's not what this is. I don't know, that's a
That's
guarantee.
not what this is. So you're saying this is a guarantee to be repaid?
No, I said that's not what this is.
Okay, so what I'm saying is, kind of like that old commercial, there's an app for that. There's a product for that, for a lender who wants insurance that they'll be repaid and nothing more. Is that,
I think that's called a guarantee.
well, here, okay, so comparing to here, and I'm trying to get to you're saying I think what you're saying is what's being guaranteed is the marketability of the title once the lender has to move past and go to foreclosure?
No, I'm saying that the title insurance policy insures loss or damage resulting from a diminution in the value of the insured deed of trust resulting from a defect, such as the mechanic's liens. It insures the value of the deed of trust. So if you look at the out-of-state cases, for example, what they're making the same point. For example, in this case, if the mechanic's liens had been only $10 million, then Universal and VRCP still would have had $20 million in equity to recover from Centerpoint. There's no damage. Commonwealth would have argued there's no damage. They'd be correct. That's what these cases say. What they also say is that if the insured lender is out of the money because of a lien that is not covered under the insurance policy, then the fact that there are mechanic's liens or other defects that are covered don't create damage because the lender's out of the money to begin with. But it's all about the difference between the fair market value of the property without a defect and the fair market value of the property with a defect. So the other point that I said I would mention in a minute is that under the terms of the contract, the insureds had the right to have their losses calculated as of the date they made their claims under the policy.
So let's accept that, your point that's a damage. But isn't that a damage only to the extent the incurred debt isn't paid?
At that point, you have to decide at what point it's being calculated. As an expert testified at trial, the damage occurred as soon as the sale did not go forward in October. So, as he also testified, what matters is whether the insured has been damaged, not whether it will be in the future. And please consider also that Commonwealth is taking the position that there's never a deadline. They're never liable as long as the insured had some theoretical ability to get paid. As the expert testified at trial, this isn't a situation where you can say they might inherit money from their aunt and ultimately repay the loan. It doesn't go on forever. It doesn't include other collateral that's not insured under the title policy, which is what Universal's all about. That again, in the Blackhawk case, there's no case that they've cited where a lender was denied coverage under a lender's policy where there had been a diminution in the value of its insured mortgage, but then ultimately recovered the loan from another source. No case. The Blackhawk case, on the other hand, says that's not true. The lender in that case recovered all of its loan plus a profit, and the Supreme Court of Wisconsin said that doesn't matter because what's insured under the policy is the diminution in value. But, you know, again, under Commonwealth's position, there's never a deadline. If there's a guarantee, then what does the insured have to prove? That it sued the guarantor, couldn't collect? What if the guarantor is going to come into some money someday? Well, then they don't have to pay because it ultimately might be repaid. It makes no sense.
Counsel, Let's step back a second, because you mentioned, okay, so VRCP was never repaid its loan. So you
Right.
said that in the beginning.
That's true.
In the summary judgment, at the time of Commonwealth summary judgment, why did that argument why was there not an argument that that creates a material issue of fact? I didn't read that in the summary judgment proceedings.
Well, because there was no evidence that it had been repaid. It was strictly an argument by Commonwealth that there was at one time a draft closing statement that said, repay loan. But the testimony from all the people who were involved was that was a mistake, and there was never an agreement to repay the loan, and that the loan wasn't repaid. And there's a finding by Judge Burke that one of the conditions of the settlement was that the loan would not be repaid. So I didn't see a material question of fact. They had no evidence to contradict the facts that the loan was not repaid.
Was that argument specifically made?
What? What I just said?
Yes.
Of course.
Inside your briefings on the summary judgment? I know it was made after trial.
No, I'm at a loss, because that's always been the argument, that the
Okay.
VRCP's loan was never repaid, and that was a specifically negotiated part of the deal.
Okay.
And that Judge Burke made that finding. So.
I see you have 5 minutes and 30
Right,
seconds.
and so, but these are critical points. I mean, I firmly believe that the cases, Arizona cases, distinguish between liability and coverage. And their cases support our position. And I'll reiterate at this point all the remaining arguments in our brief and reserve the remaining time.
If I didn't say this in the order, can you stop the time? We're going to have discretion to extend, and so let's add 5 minutes to both sides. And with that, my question to you is, and I didn't see this in the briefing, and there was a lot of briefings, so that might be the, I'll wait. It doesn't matter that the loan was repaid.
Restart it.
Because of, arguably, the conduct of the insurance company. That the insurer produced and directed a narrative in which one party felt under duress, and I guess it would have been a combination of two things. The insurance company not denying the claim, and then the second point would be not moving forward to remove the encumbrance, but sort of leaving your client in a perilous middle ground, right? So the point is, was this argument ever made? Yes, it was repaid, but it was only repaid because of the conduct and actions of the insurance company by, number one, not moving forward to take affirmative action to remove the encumbrances on title, and two, not denying the insurance claim.
Well, I don't know in those exact words, but the way I interpret your question is that the argument, if I understand your question, the argument was certainly made that it was as a result of the insurance company's bad faith that the insureds were left to fend for themselves, and in Universal's case, was forced to collect from properties and from other people who never would have had to pay.
Let's be more specific, rather than fend for themselves. Payment, Universal getting paid off on their mortgage, okay? So if that can be used as a weapon against you, did you make the argument that the only reason that happened is because the insurance company carefully orchestrated?
Right, but we call it bad faith. And that, so I don't know if we're splitting hairs or if I'm not completely understanding it, but it was definitely as a result of Commonwealth insuring over these mechanics liens. It knew they were there. It never told the insureds about it. And it did that because the mechanics liens were going to be dealt with by its parent under a different policy. Then when the parent changed its mind, they didn't step up and say, we're going to do the right thing. They ran for the hills. They told Universal and VRCP they had to waive their claims.
Right, I understand that. Again, there seems to be a very substantial argument about the meaning, ramifications of the loan being repaid and what remains of your claim afterwards. And what I'm saying is that specific act, the loan being repaid, did you make the argument that the only reason that loan was repaid is because the insurance company, and then so you could take on the significance of that fact, loan being repaid on your claim?
Well,
it's not enforceable, the exclusion clause, because yes, it was repaid, but it was only repaid because there was a puppeteer behind the scenes.
well,
I didn't see that.
Well, I'm losing it a little bit because I don't know whether you're saying that that was the intent of the insurance company or whether it was the result of its actions. It certainly was argued that that was the result of its actions. But let me back up. Let me back up, if I may, Your Honor. What they're saying is we can commit whatever level of bad faith we choose. We can consciously attempt to hurt our insured. But if they, through their own foresight of having other collateral, or by virtue of being able to negotiate a sale of their claims against us, are able to recover money, we're off the hook. Well, it doesn't work that way. That's what the collateral source rule is all about. But consider, please, the nature of that argument. That can't be right. That you can abuse the insureds as much as you want. And if they're able to recoup something from other sources, you're off the hook. That's just not the law. And VRCP's loan was never repaid.
You want to reserve?
Yes, if I've sufficiently answered your question.
Yeah.
Thank you, Your Honor.
Okay. Counsel.
Good morning, Your Honors. David Satnick, Loeb & Loeb, on behalf of Commonwealth Land Title Insurance Company. With me today is my co-counsel, Robert Burke, of the firm of Jones Skelton. It's indisputable that the insured lenders were paid in full. Not only were they paid in full for their loans, but they received profits, astronomical profits in the case of Universal, $17.89 million, with a return of 107.5%. And in the case of VRCP, they received $883 of profit, yielding a return of 17.68. Thus the indisputable evidence, which is Trial Exhibit 130, demonstrates that the insureds suffered no loss. And a title policy, as Your Honors recognize it by your questions, ensures actual loss resulting from a defect that creates or causes the diminution of value of the property. And CMLC is simply wrong in stating that a title policy ensures the value of a deed of trust, because that statement is incomplete. It ensures the value of the deed of trust to the extent that it results, by reason of the defect, in the lender being unpaid. Here it's undisputable that the lenders, both lenders, were fully paid.
Does it matter? I guess I'm looking at the exhibits that were attached to CMLC's post-trial motion for reconsideration on this point, and it does seem like the testimony and the record at trial at least supports the contention that although money went to Universal and VRCP, it was not loan repayment money. Actually, those loans remained open at that time. the fact that the numbers matched certainly gives somebody pause. But are we to ignore the testimony at trial, ignore the sort of corporate form and what was happening with, at least arguably a buyout here of the corporate interests?
Well, in the case of the universal loan, the trial exhibit 130 shows that the proceeds from the sale of Centerpoint, dollar for dollar, reduced the amount of the universal loan. It's reflected in their ledger. And the obligors no longer had.
But we have the testimony that there was, and I'm sorry, I don't remember the two exhibit numbers, but there was the sort of preliminary version that included the terms payoff that the parties refused to sign because it included that term, and then the final version that uses different language suggesting it was not actually a loan payoff.
That was in respect of the VRCP loan.
Okay.
Where they sought to avoid the consequence of their payment by recharacterizing the payment as a sale of partnership interest. In essence, they're claiming that they can avoid the consequence of paying their loan by buying the lender. But the fact of the matter is, as the judge concluded, it's an artful pretense. It's really a subterfuge. It's an obligor buying the lender and thereby relieving the obligor of any further liability under the debt. It can't sue itself for the debt.
Let's assume I accept this argument, and we agreed with Judge Whitman with your argument that these loans were paid. Talk to me about how you escape what I think we said on this court in Air Freight Express versus Evergreen Air Center, that as a matter of public policy, a party should not benefit from a bargain it performed in bad faith. So to the extent that the insurer or client sort of willfully, as Judge Weinsweig was getting at, forced CMLC or predecessors into the position of having to engage in conduct that resulted in payment of these loans, the reason they walked down that path is because your client, knowing that it had no coverage defense, refused to provide full coverage, reserved its rights.
Yes, and
so you forced them into this position and then now are taking the benefit of what you forced them into. And at least in the air freight case, this court rejected that sort of conduct in allowing your client to benefit from it.
The answer is our client didn't force the insureds into anything. The insureds had an agreement to sell the property. The title company was defending our insureds in the underlying action. We were representing, and Fidelity was representing Mortgages Limited, the ML parties, in the underlying mechanics lien foreclosure action. The priority of those mechanics liens was being disputed, and if in the underlying suit in Mortgages Limited, if they had sustained their priority, because they had foreclosed out their deed of trust in June of 2010, if they had prevailed, those mechanics liens would have been wiped out and title would have been insured. Now bear in mind, the
Does
policy...
it matter whether or not there was a legitimate basis for Commonwealth to reserve rights?
Well, I think there was...
You seem to be suggesting that doesn't matter because you were in fact covering, but that's the case always. And we still have repeatedly found that a sort of unrighteous reservation of rights will give rise to these sorts
But here
of
there
cases.
was, the reservation of rights was appropriate because the policy only responds to an actual loss. And the title company, Mr. Duval, repeatedly requested information from the lenders so that he could make an assessment as to whether there was or would ever be a loss under the policy, and never received the information from those lenders. Now you may ask, well, why didn't they provide that information? And the answer is because it was to their benefit to delay repayment of their loans. They earned, in the case of Universal, they earned an additional excess of $1 million in fees as a result of the delay in the repayment of their loan. They were oversecured. The testimony is they had over $100 million of security. And bear in mind, this policy issued to Universal, because VRCP was paid in full from the Centerpoint sale, only insured $5 million of the $20 million loan. So it wasn't as though they were going to get fully paid in any event from the sale of Centerpoint or from the payment under the policy.
Did your client have any responsibility for the balked sale?
I'm sorry.
You just referred to a sale.
Yes,
Okay.
Centerpoint sale.
So, okay, balk maybe is the wrong verb. The deal that didn't go through, did your client bear any responsibility for it not going through?
No, Your Honor, that was a policy that was going to be issued by Fidelity, not Commonwealth. And Fidelity...
So the refusal to firmly take a position on the mechanics liens, and instead reserving rights and not denying.
And defending.
Right, reserving rights, not denying, and defending, that was, I mean, did that have any impact on the sale that went away?
No, Your Honor. The sale was not consummated because Fidelity declined to insure the transaction. And it was in October of 2010. Commonwealth was not involved in the commitment or title insurance that was to be issued in October. That was Fidelity, Your Honor.
And we're not talking about the insurance. I understand that point, but there was already, your client already at that point insured the marketability of title, correct?
Not the marketability of title, no, Your Honor.
Title insurance.
We insured the deeds of trust, the enforceability and validity and priority of the deeds of trust, not the marketability of title, Your Honor.
And those weren't impacted at all at the time that this sale was happening?
Are we talking about the sale in October?
The original sale?
The sale in October was collapsed because Fidelity decided that it would not go forward and insure the buyer of the property free and clear of the liens.
But that wouldn't have mattered if your client had said, we're going to cover the mechanics liens.
Well,
I mean, you're saying to me that it didn't enter the buyer's calculus, that there's an insurance company that is at least being equivocal on coverage. I understand we have another insurance policy that didn't get consummated, and I'm sure that was very important. But you're saying that this wasn't?
The claim here wasn't asserted by the insureds until November 2nd of 2010. The sale that originally collapsed but then went through in February was in early October. There was not even a claim asserted by the insureds here. The insured lenders made their first claim in this case in November 2nd, a month later.
Oh, so there wasn't a reservation yet?
No, there was no reservation. There was no claim that was pending. And
But the reservation did precede the February sale that was sort of forced into place because of these, both of your clients.
I don't know what you mean by
reserving rights.
forced into place. What the insureds did, and we know because we know the Fidelity side of that equation, what the insureds did was enter into a collusive Morris agreement. And unfortunately, because we're here today as representing Commonwealth, Commonwealth did not appeal from that decision. But the Court of Appeals, this court set aside that Morris agreement on the grounds it was a collusive arrangement. And I would submit this is really just an extension of that, this notion that you could buy the lender or avoid and artificially extend the title policy liability by having the payment dollar for dollar equal to the debt somehow survive.
Well, so let's go then with...
But there was no force. We didn't force them to sell. They made the decision to go forward with that Morris agreement that the lenders were a party to.
Doesn't that sort of ignore the factual situation that they found themselves in, that they're, the sale that was to save everything, Fidelity blew up at the last minute. So they're in the position of, they're running out of money. It's going to be worth nothing. So
But
gun
that's
to
the
head
borrowers.
is,
But you're addressing the borrower situation. We're here with the lenders. The lenders had nothing to be concerned about.
Well, of
In
course,
fact,
we-
when they made, if I may finish, when they made their demand, when they filed their claim, they didn't even make a demand for payment under the policy. They asked for only one thing, a defense, and we supplied that defense. And because they were submitting their claim without the background and the documentation and information we needed in order to assess what their posture was, we reserved our rights appropriately.
So as your colleague said, this wasn't just a guarantee. I mean, it wasn't a guarantee. I mean, what is the significance of title insurance? It goes beyond making sure a lender gets repaid the cash at the end of the day. So what could the lender have done here? If there was a default, you could foreclose, you could have sales. Couldn't the damage figure far surpass the amount of the loan plus interest?
I don't see how, Your Honor. In the case of ERCP, they were paid in full. And in the case of Universal, they had over $100 million of collateral that was securing their loan. And it's interesting, they elected only to insure the Centerpoint for $5 million, not the full amount of their $20 million loan, because it represented in their mind, a quarter of the potential exposure. They were sitting pretty. They were in no rush. That's why Universal agreed to allow VRCP to be paid in full, even though they were in a first position, because it benefited them under the terms of the loan agreement to defer payment of the loan and to let it extend out. And if you look at Trial Exhibit 130, you'll see that as a consequence of that delayed payment, they received an additional $1 million+ in fees. They benefited. They didn't suffer a loss. They didn't suffer a detriment. And I think you need to focus on the fact, and you started out asking this question, Judge, they are sitting here in the shoes and the clothes of the lenders. And in those shoes and in those clothes, their pockets are overflowing with profit. They did not suffer a loss. They didn't suffer damages. And regardless of how they style their claim, whether it lies in contract or in tort, it's the same thing. There's no loss, there's no damage. They were made whole, and then some.
Counsel, the point was made earlier that the nature and character of the payments was not a repayment of the loan. And you noted what Judge Witten's response was on that, but how is that not a disputed issue of material fact and therefore inappropriate for summary judgment?
Because I think that the court can look at the substance and look past the form. And I think the court can, as a matter of law, determine that this type of artful pretense is not permitted. It's a sham. It's a subterfuge. And the court can readily see through that. It doesn't create an issue of fact. If an obligor buys the debt, that debt is extinguished. He no longer has any obligation to pay it. If he buys the partnership interest in the entity that owns the debt and pays dollar for dollar the amount of debt, that debt is extinguished. Is he going to sue himself to recover that obligation? Does he have an obligation to pay a penny after that transaction? So the debt is extinguished.
Are you arguing that that when investors change hands, that there's some sort of merger that happens so that we ignore the corporate form and we just merge whatever the obligations and rights of the owners are of the separate entity? So we should just ignore the entity?
It's when you ignore the entity when there is a merger of interest. That is the law. If a mortgagor
What's your best case for that?
Well, if a mortgagor requires title.
What's your best case for that?
Well, I don't have a case off the top of my head, Your Honor, but if you look at, for example, if a mortgagor acquires a mortgage against his own property, the law deems that to have been a merger of interest, and the mortgage is extinguished. It's the same thing. If an obligor buys the debt for the same amount of the debt and holds the debt, that obligation is extinguished. He can't sue himself. It makes no sense. And the court, there's no issue of fact about that. It's not as though they had separate beneficial interest, that a third party bought the loan and retained it and they're still obligated to pay it. They have no obligation to pay it. It's extinguished. It doesn't exist anymore. And it's a subterfuge to try to, a sham transaction to try to keep the debt alive, when in fact the partners of VRCP were paid every penny and then some for the debt. And the court, as a matter of law, can easily pierce that sham and say, no, it's over. The debt is extinguished. And in the hands of the obligor. And just think about it. If we were to pay, under the subrogation provisions of the policy, if we were to pay the amount of the indebtedness that you claim, that they claim still survives, we would then have the right to sue them, standing in the shoes of the lender, for the same amount of dollars. Our subrogation rights would extend to sue them on the debt. But there is no debt anymore. They extinguished it. And if they didn't, then we have the right, if they were to recover under the policy, to sue them for it.
So I find it somewhat interesting. You're saying, okay, well, we need to ignore this corporate form over here because this is a sham, but then Fidelity and Commonwealth are acting in concert through most of this litigation, and you say, no, we must observe scrupulously the difference between the two. I find that a rather interesting distinction. During the negotiations, you would agree with me that both Commonwealth and Fidelity were operating underneath a single claims administrator.
Yes, I would. And he's sitting in the courtroom today, Mr. Duval.
Okay.
Yes, it was handled by the same claims because it arose out of the same set of circumstances. The mechanics liens who were claiming it hadn't been established, it hadn't been adjudicated, they were simply claiming they had priority, but that issue hadn't been adjudicated by the court. And it may be that the borrowers, not the lenders, but the borrowers were placed in a situation where they needed to get some relief and entered into their agreement. Unfortunately, the agreement they entered into, unfortunately for them, was collusive, as the Centerpoint decision holds.
I think what Judge Faria might have been getting at, or at least one thing that I have concern about on the Fidelity and Commonwealth working under one claims adjuster, is that when there were settlement offers made, in this litigation and now we hear, well, all of those settlement offers were, obviously far above the Commonwealth policy limit. But at the time of these negotiations, when the settlement offers were made, Fidelity was there with their $130 million policy limit.
That's correct.
So not a single one of the settlement offers was actually above the total policy limit.
Well,
so doesn't this sort of...
Your Honor, Fidelity had a 3A defense that these mechanics liens were caused by Mortgages Limited failure to have funded its loan. This court in the Osborne decision upheld that 3A defense in in that case, and it's the same circumstances. Fidelity had a valid 3A defense, and this court has so held in Osborne. So now the question is, well, what's Commonwealth's situation? Commonwealth is insuring a lender. It's defending the insureds against the claims of the mechanics lienors. Those claims have not been adjudicated. They have not established priority. The insureds are oversecured and fully protected, and they haven't established or even shown that they would ever suffer a loss under the policy.
So let me ask you, counsel, see if I can get you to a certain point. Would you say that your client's title insurance policy insured the priority of a lien?
Yes.
Okay. And would you say that the lien lost its enforceability as, well, I guess, became unenforceable based on the conduct of your client, meaning a reservation of rights and not denying?
I don't see how the lien became unenforceable. The lien remained fully enforceable against the property. It was subject to a claimed senior lien, but the mere presence of an alleged senior lien does not cause a lender to sustain damages or loss until it's adjudicated to have priority. Now, it may have delayed, it could have potentially delayed foreclosure if that's what the lender chose to pursue. And then the question is, well, is the lender being compensated for that delay? Yes, here they received interest between the time of the original planned sale in February, fully compensated, and in the case of Universal, not only received all the interest, they received the additional fees as a consequence of that.
But if you're losing priority, you're losing some measure of enforceability. I'm not saying all, but you ensured the priority of a lien.
That's correct.
And through your client's course of conduct, did you in any way jeopardize the either enforceability or worth or value?
No, Your Honor. No, this is not a case where the borrower is defaulted, the lender wants to recourse its collateral, and as a consequence of the existence of the senior lien, claimed senior lien, and before there's an adjudication, the lender is held back and can't exercise its secured rights and foreclose, and doesn't get compensated for the time period it takes to get to that foreclosure. They were compensated here. It wasn't a foreclosure, it was a sale, but they were compensated for that delay. So, and it's not a situation where, let's say in Johnson Bank, where the property lost value during the time it took for the bank to get to the foreclosure of the deed of trust, and the court was concerned, well, the value of the property is diminished, that shouldn't be to the benefit of the title company, to the detriment of the lender. Here, the property was worth $30 million in October when it was originally planned to be sold, and it was sold for $30 million in February. So there was no consequence, no harm, no loss associated with the fact that in November they made a claim asking us to defend, no demand for payment, and in February they entered into the transaction that they did, which resulted in a full payment of their loan in the case of ERCP, and resulted in a payment of over $4 million in the case of Universal. And then Universal proceeded to recourse that it had against other collateral security, which it always intended to proceed against, which is why it only insured the Centerpoint for $5 million, not the full $20 million of its loan, just $5 million, because it was seeking recourse against all of the collateral.
So your argument is diminution is not the proper method because to value damages, because there are no damages.
That's correct. And every court in every land has so held. And there's not a single court that is held in the context of a lender's liability policy that the proper measure of damages is the diminution of value of the lenders. And I would cite to the CMEI case of American Title, which is the Florida Court of Appeals. And that court says, a mortgagee's loss is measured by the extent to which the insured debt is not repaid because the value of the secured property is diminished or impaired by outstanding encumbrances or title defects covered by the title insurance. Therefore, superior liens or title defects in claims may exist, which reduce the market value of the security of the security property, the value to the owner, yet result in no loss or damage to the insured mortgagee because the effect of the title problems does not reduce the value of the secured property below the amount of the indebtedness secured, or because the indebtedness is otherwise secured or paid. And that case was cited with approval by the California Court of Appeals. It's articulated in the Call versus Commonwealth case and the Green versus Evesham case.
So we can all agree, though, it hasn't been decided in Arizona.
I don't believe that there is a direct case on point. You're right. That's correct, Your Honor.
I don't believe, no, okay.
I have 2.44 minutes. I don't know. 4 minutes left. 4 minutes left?
No,
239.
So I'll reserve that time, and if you have any questions regarding any of the trial court rulings, Mr. Burke is here to address those.
Great, thank you.
Thank you, Your Honors. In general, I want to say I appreciate that you've read carefully the briefs because Mr. Satnick has said a number of things that conflict with the actual evidence. We're very careful in the briefs to tie every statement to testimony, and I don't have the time to try and track all of these down. Also with the citations to the cases. I'll deal with that first. CMEI dealt with a situation where there was other collateral secured under the insured under the title policy. That's not the case here. Again, Johnson Bank says the lender's diminution in value damages are to be calculated as of a particular date. Equity Income Partners is a diminution in value case. Citicorp is a diminution in value case. Blackhawk, which they cited, showing their penchant for doing snippets rather than meaningful review. Blackhawk said exactly it's diminution in value, and the fact that there's other collateral not insured under the property is irrelevant, and the fact that the lender ultimately got repaid from that other collateral is irrelevant. That's another case. Their claims handbook says the same thing. Now, what happened in October is Universal and VRCP were going to receive $19.5 million from the sale of Centerpoint. All closing issues had been resolved. Commonwealth was proceeding on the basis that that was going to occur, and that because its parent was going to take care of the mechanics liens, it could collect additional premiums by selling insurance to Universal and VRCP. So what happened? Immediately, when the sale was jeopardized on October 5th or 6th, Universal's representative contacted Commonwealth's title agent, said, we need to get paid. This is outrageous. We didn't even know about these mechanics liens. We want compensation from the insurance company. What then happened is Keith Hendricks negotiated with this Fidelity National Title Group, which does all the underwriting and all the claims handling for these entities, and on behalf of Universal, VRCP, and the owners. And he was making substantial headway, he thought, in October. The sale deadline had been extended to allow these negotiations to occur. And then suddenly, and they made offers that were within policy limits, even under the Commonwealth policies. And as to that point, I want to make, I think, an important point. It's not a question of what the mechanics liens would have accepted. This is a first-party title insurance policy. So the claim is between the insured and the insurance company. And the insureds were telling the insurance company, we'll cap your liability, Fidelity and Commonwealth, at $10 million. And you guys can litigate whether you have coverage defenses and get off the hook entirely. That was an offer within policy limits by the claimant, which is the insured. Then, at that point, Mr. Duvall, who is then acting as claims administrator in October for Universal and VRCP's policies, says, no, you have to waive your claims, or we're not even going to talk about settling the liens under the Fidelity policy. And that's because, as Mr. Satnick got into, they thought they might have a defense under 3A under the Fidelity policy, but they knew they were on the hook under the Commonwealth policies, so they tried to leverage the insured's desperation to settle.
And that's in the memo, right?
Making a
Duvall's memo?
Yeah. Well, yeah, I think that it reveals that was the strategy all along,
Okay.
Your Honor. And so, and Mr. Duvall, while acting as claims administrator for Universal and VRCP, refused to issue the new title policy. They say, oh, that's Fidelity. It's Mr. Duvall, the actual claims administrator for Commonwealth. And it's not taking into account the damage that that's going to inflict on Universal and VRCP. And it's very real damage. They didn't get $19.5 million. So they had to scurry around and negotiate on their own and try to salvage something out of it. And the owners said, hey, they're not entitled to repayment on their loan. The equity value is zero. There's $38 million of mechanics liens and a $30 million piece of property. They have no equity in the property. That's another case, Twin Cities, that they cite. It says damage occurs when a defect reduces the value of the property, and as a result, the lender can't recover the equity from the property. It's all about the property. I'm out of time. I wish I wasn't. Thank you very much.
I appreciate it, counsel. Thank you for your argument.
Thank you.
And to the extent you have additional questions, I have 2.5 minutes, and if you have any questions regarding the other trial rulings, Mr. Burke can address those. That's your pleasure.
I think we're going to spend lots of time with the briefing, even beyond today in conference. So I don't have any questions, but do you have any, what other arguments do you want to
The one thing I would note, Your Honor, that Mr. Lorenzen makes this argument about Commonwealth wanted the waiver of claims. That was in the context of Fidelity stepping up and funding a settlement. And Fidelity's position was, okay, if we take care of this situation, then we would fully expect that the lenders would withdraw their claims because Fidelity is stepping up to resolve it. That's a distortion that Commonwealth insisted on the waiver of claims. It's very significant that the claim that was asserted by these lenders wasn't asserted until November, a month after the transaction cratered. And when it was asserted, they asked for one thing: defend us, which we did. They didn't say, oh, by the way, we lost $19.5 million by reason of the cratered sale in October. They didn't say, pay us the policy limits. It's very significant. Look at their letter. And in response, Mr. Duvall says, okay, we'll defend you. We're reserving because you've now made the claim. We don't have information. Provide the information to us. And he asked not once, not twice, but 3 times, please provide the information so that we can make an assessment as to whether you're going to suffer an actual loss.
Was that before or after the memo?
What's that?
Was that before or after Duvall's memo?
This was before Mr. Duvall's memo, and that memo deals with Fidelity. It's an aside on the Commonwealth side of it. All it says on the Commonwealth side of it is there are no known coverage defenses. And that was that. But that doesn't mean there's liability under the policy. That means we don't know of any defenses at this time.
But it does mean that you took a reservation of right with no known coverage.
Because we didn't know if there was a loss. Exclusion 3C of the policy is express. There's no coverage if there's no loss. So how do you not reserve your rights when you don't have any information to assess whether or not there's been a loss? And there's no title company is clear. It pays for actual loss, not theoretical, speculative, possible losses, but actual losses. And here, this document, the board says it all. There were none.
Thank you.
Thank you.
Thank
May I
you.
have 30 seconds? If I'm out of order, I apologize. But
I mean, I would certainly say no in every other case.
I don't mean to be a problem.
But I guess because there is a cross appeal, you can have 30 seconds.
Thank you, Your Honor. Just to say, this business about not making a claim until November is another ruse or fiction in and of itself. Universal and VRCP contacted the title agent right away. There were then a month of negotiations, and FNTG was actively negotiating settlement, and it was only then that they said, well, now you're going to have to waive your claims, and oh, by the way, you need to submit a formal written tender. The expert at trial testified that was not necessary. It was another hoop to make the insured jump through. Thank you.
No problem. And I can assure you, we will spend even more, much more time in the record because that's what we do.
Thank you all.
Thank you very much for your argument, both of you. Well done. And we will take it under advisement and have a decision in due course.
Thank you, Your Honor.
Thank you very much.